Hi, everyone. Thank you so much for joining us for regulatory and transactional updates for hospitals and health systems. We're just going to pause for a couple of more minutes to let people join. We have a long list of people joining the waiting room right now. So we will try to start here in about 2 minutes with the content. Thank you, everyone, for hanging with us. It looks like most of our attendees have been able to join, so we'll go ahead and get started. Like I said, for those of you who weren't on a couple of minutes ago, thank you so much for joining us for regulatory and transactional updates for hospitals and health systems today. This is part of our webinar series that we hold for various hospitals and health systems. And if you've joined us before, you know we often talk about regulatory updates. We talk about transactional joint venture structures. We talk about key movement in the marketplace just from a transactional and business perspective. But today we're planning on discussing both regulatory and transactional issues. It is intentional that this webinar is going to hit a wide variety of topics just to give you an update on the many evolving issues that have been happening in 2023, such as case law, advisory opinions, settlements, different proposed rules. So we are going to jump around a little bit to make sure that we're hitting the high points and you are well informed on the key developments. Just like we do on any of our webinars, if you have questions or you'd like to talk about these issues in greater detail, please feel free to reach out to Gretchen and I. We're always happy to talk about it. So today you'll hear from myself. My name is Kayla Marty. I'm a partner in the healthcare group, and then Gretchen Townshend, who's also a partner in our group. Gretchen and I lead part of our hospitals and health systems working group, which I know that you all likely receive emails and webinar invitations and event invitations from us fairly frequently. And our actual work with day-to-day clients tends to consist of counseling on major regulatory issues, self-disclosures, and then also completing large transactions for hospitals, whether it be in joint ventures or hospital-hospital acquisition. So most of you on the phone that I can see have some type of connection with McGuireWoods in at least one of our subsectors. For those of you who might be new to us, McGuireWoods is an international law firm with 24 offices and more than 1,000 attorneys firm-wide. But Gretchen and I both sit in the McGuireWoods Healthcare Group, and that our group services a number of different subsectors, from hospitals and health systems to surgery centers to imaging facilities to radiation therapy sites, private equity funds, and across the board, many, many more. There's more than about 55 attorneys who spend 100% of their time on healthcare with Gretchen and I in our group, and then about another 100 attorneys who spend a significant amount of time, whether it be in tax, debt finance, private equity, or other subsectors. So if you ever have any questions, don't hesitate to reach out. We'd love to talk to you. We love to make more connections in the marketplace. And then if you have questions about the substance of what we talk about today, you'll see on your platform that there is a Q&A box. You can type any of your questions into that Q&A box. Gretchen and I will do our best to address them as the topics go along during the webinar, or at the end if we haven't had an opportunity to address them. Some questions tend to be extremely system or issue specific. And in those circumstances, we will reach out to you after the event and would love to talk to you more about it. For those of you who are attorneys on the phone, I see a lot of you, CLE is being offered. If you did not register with your bar number when you registered at the beginning of the registration information, please feel free to just send us a quick email after the event. We'll make sure that you're getting appropriate CLE credits. So with that, I'm going to turn it over to Gretchen to give you some highlights on our agenda and then also talk about a couple of recent advisory opinions. Gretchen?
Great. Thanks, Kayla, and good morning or afternoon to all of you, depending on where you are sitting in the country. As Kayla mentioned earlier, we have a pretty broad agenda hitting on a wide variety of topics of interest. We're attempting to provide a broad overview and key takeaways for each of the items listed here on the screen, but ideally, ultimately looking at a couple of different buckets of things. First, what is the government looking at today? Where are they settling cases, issuing guidance, things that they are frankly concerned about, violations of the law and the like. You'll see there's a number of those things: antitrust, False Claims Act, et cetera. We're also going to talk about some key legal updates applicable to operational issues for hospitals and health systems, things that you should know as you are running your business to comply with the changes in how the law governs what you do on a day-to-day basis, HIPAA updates, things of that nature. And then finally, a brief overview of what is happening in the transaction market, how are businesses changing and consolidating and separating and the like. So we're going to try to hit on those variety of buckets. And as Kayla said, each one we'll hit on quickly and then absolutely available to answer additional questions you may have. So first issue is turning to some advisory opinions that have recently been published. As most of you know on the phone, an advisory opinion is an opportunity for providers and other folks in the market to ask OIG whether a particular arrangement that they are engaged in that might otherwise implicate the anti-kickback statute may ultimately be permissible. And what the OIG does is issues these advisory opinions to provide guidance on the anti-kickback statute, which, as you all know, is the criminal statute which prohibits the payment or receipt of anything of value to induce or reward referrals of federal healthcare program business. So the anti-kickback statute has certain safe harbors that protect various arrangements which meet each element of a particular safe harbor. But as you know, failure to meet a safe harbor does not necessarily make an arrangement illegal or improper. Unlike our friend, the strict liability Stark law, intent is really critical in assessing anti-kickback statute risk, and that is something that is focused on in these various advisory opinions. And so ultimately, if an arrangement is deemed to violate the anti-kickback statute or not, is going to turn on whether or not one purpose of the arrangement is to induce or reward referrals. So with that background, let's jump into our most recent advisory opinion that was just issued a couple of weeks ago. And this is one that really speaks to the scope of the employment safe harbor, which protects compensation paid by an employer to an employee, where the facts here really drive from the ability of a practice to compensate their employed physicians for revenues received from an ASC distributions associated with that physician's referrals to the ASC. So the person who submitted the requester was a physician practice, had 11 physician employees, and operated 2 ASCs within their corporate umbrella. The ASCs were part of the practice, not separately designated legal entities. And the practice said, look, we want to pay our employed physicians a bonus, compensation bonuses for each surgical procedure they perform at our ASC. And we want to make that payment out of facility fees, not the professional fees associated with that service, but the facility fees that the ASC receives, the collections that it receives related to the procedures that employee performs at the ASC. OIG ultimately said, yep, that's okay. The employment safe harbor in its breadth protects this compensation to practice employee physicians because they, as the requester noted in their request, these are W-2 actual employees of the practice, paid compensation in accordance with what the safe harbor indicates. And so the OIG said, yes, this compensation is protected. Now, any of you that have looked at these issues in the past know that that is interesting, or may have noted that that was interesting, because typically ASC facility fees are viewed outside of physician compensation arrangements because it is not a professional revenue. It is not professional revenue associated with the professional service. And as the ASC safe harbor, which is a different safe harbor to the anti-kickback statute, outlines, the government is very concerned about how those facility fee revenues are distributed to referring physicians. But in this case, OIG focused on the relationship between the payer, which the practice, which was the employer who owned the ASCs, operated the ASCs, and the recipient, which was truly an employee. So again, a real example of the breadth with which OIG views this safe harbor and compensation paid to employees by a bona fide employer in this favorable advisory opinion. A couple of caveats here. We have to be very careful about the extent to which this is extrapolated to other situations. The OIG indicated very clearly that a different corporate structure may not qualify for the same safe harbor. For example, if the ASC was a separate legal entity, a wholly owned sub or a joint venture sub of the practice may not get the same treatment. They explicitly stated that compensation to independent contractor physicians, or importantly, owners of the physician practice, were not addressed here. Those are not deemed to be W-2 employee compensation by IRS, so those would not be protected by this explicit safe harbor, and explicitly did not extend the payments made to the physician owners of the ASC paying themselves bonuses as distributions. So in a circumstance which is a bit more traditional than practice ownership and operation of an ASC, if individual physicians were owning in the ASC, getting distributions that varied based on their own referrals rather than W-2 compensation. Finally, like all advisory opinions, the disclaimer that this is only to be relied upon by the person who submits the request, although these advisory opinions do give us a good sense as to what the government views about certain kinds of things. So again, the takeaway, the employment safe harbor is viewed very broadly. The anti-kickback statute safe harbor for employment does not, importantly, require that that compensation be at fair market value. But for you all, hospitals and health systems, you also have to deal with our friend Stark. As I mentioned, the employment exception to Stark does have a fair market value component to it. So again, the extent to which we can rely on this for certain financial arrangements is very helpful in understanding what OIG's views are, but may ultimately not give as much flexibility as folks might have otherwise hoped. The next advisory opinion that we're going to talk about came out a couple of months ago. This was an unfavorable review from OIG related to a neuromonitoring contractual joint venture. In this case, the requester was an entity that performs intraoperative neuromonitoring services. They do the technical piece. They employ a neurophysiologist to perform the technical component of the intraoperative monitoring. And then they contract with a physician practice who uses neurologists to perform the professional component. And then when a surgeon has a surgery that needs this neuromonitoring, they contract with this organization to provide the neuromonitoring services. One of the really interesting things about this advisory opinion is that it appears very much that it was a defensive request. That is a question posed by this company who ultimately indicated in their request that their competitors were pitching this structure to their clients. And so they were almost seeking a negative advisory opinion so that they could show their clients. Seem like, ultimately, we don't know the details here because it's all confidential, but certainly seems like they were seeking a negative opinion from the government so that they could tell their clients, look, you can't do this. The proposed arrangement was essentially a contractual joint venture, to the extent you guys are familiar with that construct, where a new monitoring company, NewCo, would be formed that would be owned by the surgeons who are the ones who are ultimately requesting the neuromonitoring services. And then that NewCo would subcontract with the requester and the neurology practice to perform those technical and professional components in exchange for a fee. NewCo and the surgeon owners would retain a profit differential between the reimbursement for those services that were ultimately received by NewCo and the payment made to the requester and the practice. So that ultimate delta in there was retained by the referring surgeons. And again, because this appears to be in a defensive posture, the proposed facts were presented in such a way that I think was helping to drive at the negative opinion. For example, one of the things they said is, look, we can't guarantee that federal healthcare program beneficiaries are going to be excluded here. And also, NewCo isn't going to have any expenses or operations other than the outsourcing to the technical neuromonitoring company and the neurology practice. So they don't have any exposure or whatnot. Ultimately, the government came down where we would expect, based on the way that the facts were presented here, that the proposed arrangement involves several forms of remuneration, which would induce the surgeon owners of the new company to make the referrals for the intraoperative monitoring services to NewCo, and requester creating a risk of fraud and abuse. For example, there were discounts on the services being provided under the personal services agreement between the practice and NewCo. So in essence, the neurologists received less from NewCo than they would from a payer. So that delta was retained by NewCo. The delta between what NewCo would pay requester, which was the technical services company, and what they would get on the open market, and those would be distributed to the referral surgeons in the form of an investment interest. OIG went on to discuss its long-standing contractual joint venture guidance, in which a provider of services, here the requester, contracts with referral source physicians, here the surgeons, to help them set up a company to provide a new service line that the service provider used to provide alone, so that to service the referring physician's existing patient base, essentially allowing the surgeons to share in the profits of that service line while outsourcing the actual operations of the service line. So they reiterated that we are still concerned about these contractual joint ventures. Our guidance, which has been in place for decades, still stands. So that is ultimately the key takeaway here, that any sort of arrangement between referral source physicians and providers of services in the market, where the physicians are really just bringing patients and not bringing capital, not incurring financial risk, and those types of things are going to continue to carry pretty significant risk under the anti-kickback statute. Again, same disclaimer, this is for this group only, but it certainly appears that the requester will take this advisory opinion to its clients and say, don't leave us and go with this other company because what they're doing is illegal. See, that's what OIG said. So now we're going to transition back to Kayla, who's going to go through some recent FCA cases and settlements and litigation.
Thanks, Gretchen. So like we said at the beginning, we're just picking and choosing some of the settlements and advisory opinions that are particularly interesting to us. Hopefully they're also particularly interesting to you. So this is one False Claims Act settlement that I thought was instructive and interesting, both in the way that it arose, the way it was settled and some of the claims at issue. So we'll just dig into this. This settlement came out this year, but it had been ongoing for quite some time before that. So you'll see if you read the claim and the settlement, it's alleging that a regional hospital system engaged in improper financial relationships. And there's several of them, and we'll discuss them with different referring physicians. One thing about this claim that I think is a helpful reminder and a really interesting part of the settlement is that the total settlement was about $69 million, which obviously is a very significant amount. The payment to the U.S. government was $67 million, and then the payment to the state was about $1.8 million. And then there were also separate physician settlements as well with the government. And so it's just a helpful reminder that when you have scenarios that implicate the federal anti-kickback statute, the False Claims Act, Stark, you often will have multi-players driving those settlement discussions. So, right, the federal government, the state government, and then also this is not only against hospitals and health systems that we see, we also see corresponding settlements against physicians. And in this case, the settlement with the hospital was actually sealed for quite some time until the settlement with the physicians could be reached. So that multiplayer dynamic was present here and is commonly present in these different settlement discussions around the False Claims Act. The other thing that's interesting about this particular settlement is, like many, it was brought by a whistleblower relator. And it was brought by a fairly high-level employee at the organization following that employee's termination. And that's also a fairly common fact pattern that we see in circumstances that have settlements or other allegations of False Claims Act or anti-kickback statute or Stark violations. So that's just a good takeaway and reminder within each organization to keep knowledge groups small, try to contain the ways in which these various issues are being discussed, and obviously do so in a compliant manner, but always be managing potential whistleblower risk in the future. And so in the allegation for the claim itself, the former employee essentially said that the hospital was rewarding top referral sources with compensation, remuneration, and then other favorable business arrangements. That was the allegation in this scenario. And each of these allegations were separate, so we'll tick through them here, and they're always something to be on the lookout for with respect to any hospital or health system organization. So the first was they were alleging that there was awards of medical directorships and then other appointments that were viewed to be kind of prestigious or important appointments at the hospital in exchange for referrals. So some of the highest producing referral sources were seeing these appointments where lower producing referral sources potentially were not seeing the appointments. And then there was the allegation that the compensation for those appointments were outside of fair market value. So that's a good reminder to always be looking at the way in which the organizations are selecting individuals for certain positions, and then also looking at the fair market value of those services that are being performed. The other component, which is interesting because we get this question at McGuireWoods a lot, is what type of services are able to be provided to referring physicians within the hospital setting without it being considered remuneration. And in this claim, there was an allegation that the hospital was retaining employees to provide to independent physicians, such as physician assistants, assistance with billing, assistance with other administrative services, and those services were tantamount to quote-unquote remuneration or a gift to the physician because the physician did not have to pay for the labor to provide those services themselves. So we commonly see questions related to nurse assist, physician assistant assist in the hospital setting. This is just a reminder to be looking at those issues critically in light of various settlements that we are seeing, this being one of them. And then the last couple of allegations were that the hospital was paying overhead costs of independent physicians as remuneration if that physician was a significant referral source at the hospital. And then they were also accessing services at the hospital rather than paying for those services themselves within their physician practices. So that's just a good reminder as an organization to assess the access that especially independent physician groups have to hospital services and resources that otherwise would need to be purchased externally, because that potentially could be viewed by the government as remuneration in certain circumstances. And so ultimately the claim was a claim for violations of kickback and start, which provided the basis for a False Claims Act action. Of course, the settlement here was quite high, and anytime you have a settlement very significant like this, there are often additional factors. In this case, one of the factors was there was no oversight and maintained or record keeping that could substantiate some of the services and fair market value nature of the relationship. So certainly that likely increased the potential liability associated with this claim. These are just a few other False Claims Act case updates, and these are interesting because they are not just substantive in the reason why we care about them. So the first one here that's listed is one of the first decisions that have ruled on what's called the benefits conversion statute. And it essentially confirmed that once providers receive reimbursements from the government, they can spend those reimbursements and utilize those reimbursements as they see fit without further restriction. So in this suit, it was actually filed back in 2012 against Catholic Health System of Long Island. The whistleblower in that circumstance claimed that the hospital had incorrectly routed reimbursements for services at their nursing home. So it was St. Catherine of Siena Nursing Home, and they had routed the reimbursement after receiving them to St. Catherine of Siena Medical Center. And the allegation was that was improper, the way in which that monetary routing was happening. The hospital disagreed and said under the benefits conversion statute, that was not the case. They were free to use the funds as they saw fit. The case in that circumstance said there are no forward-looking conditions to those reimbursements to be used in a specific way from Medicare. So that was really interesting just because it was one of the first cases to ever rule on the benefits conversion statute. So that's more of a procedural point than a substantive point, but one to definitely note. The next case that's listed here on the slide is also particularly interesting because it came down in favor of the health system. The substance of the case is not particularly interesting. It essentially was an allegation of Medicare fraud against a hospital related to fraudulent cost reporting, inflating supply costs, and improper waivements of copayments and deductibles, which of course are things that we all know are issues that can give rise to potential allegations. But the reason that this case is interesting is actually on a procedural point that many people may or may not realize is part of the way that False Claims Act cases are analyzed. So anytime you have a False Claims Act piece of litigation for the litigators on the phone, there's a requirement that the whistleblower complaints be filed under seal. They're filed under seal with the allegations, and they're kept that way for 60 days. During that 60 days is the period in which the DOJ investigates the complaint and basically decides whether or not they're going to, in fact, intervene in the whistleblower's complaint. In some circumstances, for good cause, the DOJ can move to extend that 60-day period to give them more time to investigate. During that time that they investigate, they often will add additional causes of action or claims during that seal period. In this case, those extensions lasted 8 years. So, of course, very long after the potential 60 days that would be typical. And so what's really interesting about this case is that it provides an opportunity for defendants, in this case hospitals and health systems, to try to check the abuse of that seal period or potential abuse of that seal period. And it makes it very clear that district courts have to look closely and scrutinize any new claims that may be added by the government, especially during these lengthy periods where they're investigating under seal. It's also pretty strong evidence that the government cannot use these periods of time to just unilaterally discover things that are going on in the case, add claims, and then toll the statute of limitations period. So what was interesting about this case is during that period of time, that 8 years, a significant amount of the statute of limitations period on the underlying claims had passed, and the court ultimately told the government that for many of the claims that happened during that 8-year period, the statute of limitations had run by the time the case was completed. And so they did not honor the tolling of the statute of limitations for that entire period, which was interesting because it really severely limits discovery. The next item here is more of a substantive topic, less of a procedural topic. This was a case that arose from an independent physician business divorce. So the case actually arose completely divorced from the hospital originally. What happened was there were two ophthalmologists, both who referred to the hospital. One of those ophthalmologists became the ultimate whistleblower in the case because that ophthalmologist, following the divorce of the two ophthalmologists' business, wanted to be employed by the hospital. The hospital ultimately decided not to hire that individual. They did not start an in-house ophthalmology practice and decided to move on into other specialties. When the ophthalmologist found out that they had not been hired, they asserted that the hospital had made that decision not to hire the ophthalmologist because of the number of referrals that the hospital received from the other ophthalmologist that had divorced their business from the ophthalmologist applying for the employment position. The court made a pretty interesting finding here, which basically said that the lack of offering an employment opportunity to the ophthalmologist did not encompass an act that would have been considered remuneration to the other ophthalmologist that referred to the hospital. And there had to be something of actual value transferred in order for the kickback statute to apply in that circumstance. So that gave strong authority to be able to argue for various False Claims Act defendants that speculative lawsuits or lawsuits that didn't involve actual remuneration wouldn't implicate the federal anti-kickback statute. So that was a little unusual. It actually limited this kickback statute, not increased its breadth. So that's it for what we're going to talk about on False Claims Act updates. We wanted to spend a little time talking about antitrust updates. There's been an entirely separate webinar on this, so we're going to hit this really quickly for those of you who were able to attend the webinar on this topic. But just for those of you who weren't, we want to make sure that everybody is aware that there are many new statutes in many new states that involve healthcare transaction reporting. They don't just impact hospitals. They don't just impact physician practices. They don't just impact management companies. In many cases, they impact all of those things. So here on the slides, you'll see there's a listing of the states who currently have implemented pre-closing notice requirements for transactions that involve healthcare entities, and there are more being added every day. So this is not the be-all, end-all list, but this is a couple of data points for you on the call. And I just wanted to give a couple of examples of covered transactions so you're aware of things to be looking for. So typically it follows a pretty similar pattern because many of these statutes are based on a model rule. So there's been changes in the state legislatures, but based on the model rule, they do follow some commonalities. One is there usually needs to be a healthcare entity. The other is there needs to be another trigger, whether it be an acquisition, a contractual joint venture, a services relationship, something like that, that is often significant. There often needs to be a threshold. So for example, in New York, the threshold is $25 million in revenue. So those thresholds are different in each state. You need to be looking at those really closely. And then if all of those things are present, you typically have a required notice or consent period. Some are 30 to 60 days, but there are also some as long as 180 days. So be aware of that potential issue for states that are listed here, and then be on the lookout for your state to see if there are other changes coming. One thing that we wanted to highlight that's just a point of interest is some states are using this authority very broadly. So Oregon is a good example of this. You'll see here the Oregon Health Authority took the position that the merger of Kroger and Albertson, two seemingly non-healthcare companies, actually were required to provide a notice under this potential new statute that is in Oregon. And so it essentially required a 30-day preliminary review of the merger at a state level due to the fact that both of the grocery store chains had pharmacies. And so the fact that they had pharmacies triggered the healthcare entity hook in the statute, and it does demonstrate pretty broad review power. So that's just an anecdotal example that we thought was fairly interesting. A couple of other things that we just want to highlight on the antitrust front is around non-competes. I'm sure you all are very familiar at this point with the FTC's proposed rule banning non-competes. It's been out there for quite some time. It has not yet been finalized. There has been a significant comment period. They received a very significant number of comments. I think that the theme is there may be changes to the proposed rule to try to understand some of the bounds a little bit better. But here on this slide, we're going to pass this quickly, provide some of the contours of the proposed rule for reference. But more importantly, and something to be really focused on, are state non-compete bans. So even though that the federal rule has not been finalized, various states are starting to implement flavors of non-compete bans. That does not mean that every state on this list is an across-the-board ban for every single potential activity that could be considered a non-compete. But it does mean that it's really important to be looking critically at your state's non-compete laws, non-solicit laws, non-disparagement laws, to make sure that they're tailored in such a way that is permissible and does not trip up some of the state antitrust laws, because there are changes that are happening on a weekly, monthly basis. So here are a couple of the states to be aware of. Like I said, I'm not going to go into these in detail due to the separate webinar that was provided on this topic, but we would have been remiss if we did not mention it at all. So with that, we'll move on to a very interesting EMTALA enforcement action. This is something that your organization likely received a letter from HHS on. So there have been 2 investigations of hospitals that were accused of not offering necessary stabilizing care to individuals experiencing emergency medical conditions. HHS and CMS came out and said that that was a violation of EMTALA. Obviously, violations of EMTALA are very serious. They have very serious penalties associated with them. So this is something to be on the lookout for, because it is an area of focus right now for HHS. And the fact pattern in this situation was fairly unique. Many of you are likely familiar with it. There was a patient that had 2 visits to 2 different hospitals. The patient in the circumstance was not offered care that her doctors had actively determined was necessary to stabilize her emergency medical condition. And the physicians in that circumstance noted that the reason that the patient did not receive that care was not because of any kind of clinical judgment. It was not because of a lack of assessment of the patient, but rather there were specific hospital and health system policies in place that would not allow an abortion to be performed, which was determined by the medical provider to be the necessary care. That is a very hot button issue right now, obviously, that we're not going to talk about on this webinar, but there are a lot of different state dynamics and obviously a lot of federal dynamics around that type of care. One thing that did become very clear after this circumstance is that CMS viewed the decision as a violation of EMTALA. So hospitals, health systems, and other organizations subject to EMTALA need to be cognizant of this potential issue, and even in circumstances in which abortion care is the type of care at issue. And CMS actually issued a letter to all hospitals and health systems on this topic to basically reaffirm that across the country, it is the expectation that healthcare providers do provide any necessary stabilizing medical treatment, regardless of the type of care necessary to stabilize that treatment. It also leaves open the ability to transfer patients in circumstances that the particular hospital or health system cannot provide the necessary care. So we just did want to flag that. That is something you likely have already seen or heard. Okay, with that, I'm going to turn it back over to Gretchen on the No Surprises Act.
All right, so continuing on some of these operational items, not news to anybody on the phone. No Surprises has been in place for almost 2 years now, and the obligations for providers, facilities, air ambulance providers of all kinds. I'm not going to go through the details here. This is kind of a high-level summary. We assume that you are all working through these issues, right? The balance billing prohibitions, the good faith estimates, the disclosure requirements, and ultimately the dispute resolution process that the No Surprises Act implemented. So what are we seeing now, right? We are now almost 2 years in. What's going on the ground? So we do know that CMS is, the plan has always been for CMS to rely on patient complaints through the website. And we've started to see some active enforcement of the No Surprises Act in 2023, right? That there are complaints being filed and there are investigations being performed. Upon receipt of the complaint, CMS issues a notice to the provider. They request a bunch of information and they try to assess the validity of the complaint. There are fines and penalties associated with violations of the No Surprises Act, up to $10,000 per violation, as well as certain state-specific penalties. The key thing here, though, to note is that CMS is still really trying to figure this out, I think, and the impact and what it ultimately means. And these requests that are stemming from patient complaints can be very disruptive, even if ultimately not deemed to be a violation of the No Surprises Act. We are aware of a specific situation where a patient made a complaint to CMS about a balance bill received from an anesthesia company. And there's been some investigation and back and forth between the anesthesia company and CMS for nearly a year now. They've requested information has been provided. And ultimately what in this investigation was uncovered that the patient was in fact in network. The facility and the anesthesia provider billed the patient as though they were in network, exactly as they were supposed to do. The insurance treated the patient as in network, and the insurance, the payer, made an error in billing the patient responsible portion. So the issue is that they inadvertently billed the patient a little more than they should have based on the patient responsible portion of the bill, determined the wrong copayment. That's where we landed. The anesthesia group didn't do anything wrong. The facility didn't do anything wrong. But this particular facility and group have spent thousands of dollars on lawyers going back and forth with CMS. And CMS basically has indicated at this point that the facility and the anesthesia company are responsible for ensuring that the insurance provider is engaging correctly with the patient as well, right? So it's not just stay in your own lane and make sure you're following these rules. But we also expect that you're monitoring what's happening between the patient and their insurance provider. We will not go down the rabbit hole of how on earth would a facility do that with every single patient and the manpower that would be required to do so. But I think it's important to note that this is an important initiative for protection of patients and beneficiaries that is out there. And CMS is still really trying to figure out how best to implement it to ensure those protections, particularly when their jurisdiction is over the providers who are enrolled in the Medicare program and not necessarily insurance providers who are providing private insurance where a lot of these details flow through. Another example that they are still trying to work through the hiccups on this program is a new change and proposed rule for the dispute resolution on these payment issues, right? There's recently put out a proposed rule that says, actually, no, you need to give more information to the patients at the beginning so that they're better able to dispute the information so that we can make sure they have the information that they ultimately need. So again, just evidence that it's here to stay, and it's not a meaningless requirement, that CMS is actively monitoring this, following up on patient complaints, and certainly because of the disclosures and whatnot required, patients are aware that this is out there. So monitor and audit, make sure that your organizations are doing things as they are supposed to do as required by the statute, and that you're doing periodic audits of various providers, and to the extent you can, maybe even your insurance providers, because you want to be in a position where if you get a letter, or when you get a letter because of some patient complaints about something, that you are able to respond, here's all the things that we're doing to make sure that we've got, we are following the rule as best we can. Moving on quickly to HIPAA and data privacy update. That final rule that every lawyer you've probably ever talked to said is coming any day, and has been saying so for the last 2 years, 3 years almost, is still TBD. I think there was some feeling that maybe it would be published this year so that it could be implemented soon thereafter, and the implementation obligation is ultimately 60 days after publication. So we've had the proposed rules. We know what's in there. There's a lot of practical implications and changes that are ultimately required by the proposed rules that were issued almost 3 years ago, that is going to require changes to policies and procedures and notices and documents and all the things that you have in your toolbox related to HIPAA. But still not final. And so once it does become final, it's a 60-day effective date thereafter. And then at least what has been suggested is that then you would have an additional 180 days to comply. But it's always a good idea to be monitoring your and evaluating your HIPAA documentation and policies and procedures to ensure that you will be able to make this transition as smoothly as possible when it comes out. Another point on the data privacy is that the FTC is now taking an active interest and role, along with OCR and HHS, in enforcement actions related to online apps and websites that use tracking technology. As a covered entity, you all, hospitals and health systems, are responsible to ensure that your vendors and app providers are operating in accordance with the HIPAA requirements and data privacy requirements. And so we have seen a number of circumstances where some of these, and it's not necessarily against hospitals and health systems, but developers of various technology for health tracking systems have been selling data or providing data to Google Analytics, Meta, Facebook, et cetera, and that can trigger serious fines and penalties. Easy Healthcare, which developed a fertility app, paid a $100,000 penalty because of this tracking system. BetterHelp settled a $7.8 million penalty for similar sales of consumer sensitive information with Facebook and Snapchat. GoodRx similarly settled for $1.5 million. So really important to make sure that your apps and websites and EMR systems and any sort of online tracking technologies that you have don't have some of these tracking systems involved, because it could ultimately result in HIPAA violation and some serious penalties. And then the final operational item, as everyone knows, the public health emergency ended several months ago, which put an end to several of the modifications and waivers on the various rules and regulations that were put in place during the pandemic. However, it wasn't a hard stop for all PHE-related changes, as certain of these items were extended beyond the end of the public health emergency. And so as we approach the end of the year and we get further and further away from the public health emergency, a couple of recommendations to evaluate what, if any, additional operational changes are going to be required to ensure compliance with regulations when some of these extended waivers terminate. So we've outlined a few on the slide here. The first is not an extension. The Stark and kickback waivers ended at the end of the public health emergency, but as we have been recommending throughout the pandemic and certainly since the conclusion, if you utilize those waivers for any sort of financial relationships, please make sure they are documented and the background and the support for the use of those items is appropriately in the file so that it can be presented if questioned. Certain COVID-19 related additional service lines and the liability protections created by the PrEP Act shields liability for certain services that were added, locations that were added to address the COVID-19 pandemic. This liability shield extends. This is one thing that did not end. It extends currently until December 31st, 2024. And that extension has been continually pushed out over the course of the last couple of years. So it's not infallible, but something to note that you have this continuing liability shield because of the PrEP Act. However, making sure that you are evaluating your treatment locations, your service lines, et cetera, that you've got, you're not necessarily relying on these liability shields past that date. Supervision waivers for direct supervision being permitted to be provided by a telecommunication remotely. That is another waiver that was extended through the end of this year, through December 31st. So again, if folks are relying on that need to sunset it and revert back to appropriate supervision or traditional supervision requirements. And then finally, some additional telehealth and remote services flexibility that have been extended through the end of 2024. The practitioners who can provide telehealth services, the expanded list, as well as the in-person requirements for telehealth mental health services will once again be in effect, presumably on December 31st, 2024. But as Kayla will note in our next slide, telehealth is one of those areas which is constantly changing every single day. It seems like as CMS is trying to determine what can stay for the long term and what needs to be reverted. So I'll turn it back to you, Kayla.
Thanks, Gretchen. So this is a summary of the changes in telemedicine associated with behavioral telemedicine services. As you will see, these are proposed to be extended indefinitely, and then these same services for non-behavioral health services are often being extended until December 31st, 2024. Gretchen already covered the existence of these at a high level, and we've summarized them here on the slides. So just in the interest of time, I'm going to move past these, but happy to answer any questions offline about any of these extensions. The two things that I want to talk about on telemedicine specifically are related to a proposed DEA rule that has been extended through 2024, and then an advisory opinion. So in February of this year, I'm sure you all are aware that the DEA announced a proposed rule on online prescribing for controlled substances via telemedicine. So during the PHE, any DEA registered practitioners in any area of the United States could issue prescriptions for Schedule 2 through Schedule 5 controlled substances, even if they had not conducted an in-person medical evaluation. The new rule that has been proposed significantly limits this ability for this practice to continue, but does not eliminate it entirely. So essentially what is going to happen is for consultations without an in-person exam, the proposed rule is going to allow the medical practitioner to prescribe a 30-day supply of Schedule 3 to Schedule 5 non-narcotic controlled medications, and then a 30-day supply of certain treatment of opioid disorder drugs. But if a patient requires any kind of Schedule 2 medication or Schedule 3 to 5 medication that would be considered a narcotic, an initial in-person exam is going to be required under the proposed rule. So the flexibilities have been extended while the DEA and HHS continue to review the structure, but you need to be aware of that proposed rule as it impacts telehealth prescribing. The other impact on telehealth, which is really interesting, is a favorable advisory opinion 2208 listed here, which addressed an existing arrangement for federally qualified health center that loaned limited use smartphones to be able to enable patients to access telemedicine services. In this circumstance, in the advisory opinion, it was certified that the provider served predominantly low income and offered both in-person and telehealth services. And they advocated for increasing access to telehealth services and to combat isolation during the public health emergency, so there could be talk and text with various providers. So this advisory opinion should be viewed with a grain of salt because it was issued in connection with the public health emergency, but there seems to be notes within the advisory opinion that suggest that the caveat about it being provided during the public health emergency was largely targeted at the ability to rely on the telemedicine waivers. So still, this is very instructive for current considerations of loaning smartphone and other technology products. In the circumstance, the patient was only able to use the smartphone to make phone calls, receive phone calls, send and receive text messages, and use the health system's telehealth application, and then obviously to be able to review their medical records. And ultimately, what the OIG said in this circumstance was that they did not believe that this program was at high risk of violating the anti-kickback statute or the beneficiary inducement laws, even though they were implicated by the free service that was provided through the smartphones and chargers, because they did not think there was a high likelihood that there would be any kind of remuneration received by patients that were likely to induce overutilization, change clinical decision-making, or pose risk of safety to the patient. Rather, the free smartphones were removing a socioeconomic barrier and access to telehealth services, which satisfied the beneficiary inducement laws exception for promoting access to care. And so this is not the first time that the OIG has issued a favorable opinion with regard to smartphone loans. So this is something to be on the lookout for, particularly if your health system is looking at it. But a common factor in this advisory opinion and the others has been the smartphones are locked and they can't use the smartphones to browse the internet or download any other kind of applications. So if you're looking at a program of this type, those are a couple of factors to be aware of because they do seem to be coming up fairly consistently when these issues are looked at. The last thing, which we only have 1 minute for in our program, so I'll leave this here for you all to review and take a look at, are some key transactional and joint venture updates. These are a couple of circumstances in which we're seeing really a trend toward value-based care, population health initiatives, and use of technology to enable the patient experience. And so these are all circumstances that are not unique in the market. They're not hospital-to-hospital acquisitions. In many scenarios, they're health system to technology joint ventures, or their health system to other market providers, such as Best Buy. And I think we're going to continue to see those trends and see those opportunities throughout the healthcare system. But with that, I'm sorry we've gone just a little bit over here, but we really appreciate you participating with us today in the webinar. The slides will be available after the session if you would like to review them. And like we said at the beginning, we'd love to answer any kind of questions or have an opportunity to engage with you anytime you'd like. Please feel free to reach out. Thank you so much. We appreciate you being here.